Thanks for inviting me to speak, and I hope everyone is doing well in quarantine, and getting by. Hopefully, that will change soon, and we'll be able to go out again based on how we can manage with this virus. I thought that I would speak about the intersection between COVID-19 and the Constitution, because it's really interesting how the last 3 or 4 weeks have brought so many issues to the fore about the Constitution. It's not surprising because it's actually in times of crisis that we actually notice how the underlying structure of the Constitution and and constitutionalism works, because that's the time when it's put under maximum stress. In normal times, things go smoothly and we don't notice the underlying structure. But it's in these times of stress, in these times when these principles are being pushed to their limits, that they kind of reveal themselves in a moment of crisis. So I thought that this would be a good time to discuss what we think of constitutionalism in the context of a public health crisis like COVID-19. Now, I'll start with something basic, which is the structure of parliamentary democracy as envisaged by the Constitution. So the Constitution has a very, very complex set of institutional arrangements that decide who governs and how they govern. And one of the fundamental principles underlying this arrangement is that of distribution of power or separation of power. And the idea behind that, and this is an idea of long standing and long repute, is that if you concentrate power in one hand or in one set of hands or one authority, then the potential for abuse is great and maximized. And so to avoid that kind of abuse where one body, one person, one authority holding all the power can just completely ride roughshod over everyone else, you have the distribution of power. So in a parliamentary democracy, you have three great wings of state. You have the parliament, which is the body of elected representatives. The job of parliament is to pass laws. Then you have the executive or the government, whose job it is to implement the laws. And the government is always responsible to the parliament. The government is supposed to stay in power as long as it enjoys the confidence of the parliament. Right? So, and parliament scrutinizes, has oversight over what the government does. And then you have the court. So the court acts as a check or a balance on both parliament and on both parliament and the executive, to ensure that they stay within legal bounds and the rule of law is maintained. In a bicameral system like India, you have an additional check, which is the federal check. So India's federal structure gives you this combination of the center and the states. And the state's representation in the Rajya Sabha, the upper house, ensures a further check on what a majoritarian political party can do by way of lawmaking. So you have all these checks and these balances that operate to ensure that there are multiple power centers that exist in a democracy, and to ensure that if any one power center oversteps its limits, the others will push back and will ensure that that balance is maintained. That's the philosophy underlying modern democratic republics, modern democracies, modern parliamentary frameworks. Right? So, and you find this in different countries all over the world. Now, what we have seen in the context of coronavirus, COVID-19, and the response that has taken place in India is effectively the centralization of power in the executive at both the central and the state level, but more at the central level, and the bypassing of the other checks and balances. And the way it's been done is that you have these two laws. One law is the National Disaster Management Act of 2005. That is the umbrella legislation that's been used in coronavirus. And the other is the Epidemic Diseases Act of 1897, a very, very old colonial law that's been used by the states. And both these laws have these really wide and vague provisions that effectively allow the government to take whatever measures it deems fit to contain the disaster or the epidemic, as the case may be, based on what law you're using. So the thing is that once the government invokes the provisions of the NDMA or the EDA, then that takes Parliament out of the equation altogether. So then what happens is that through directions and orders, and you've been seeing that over the last month or so, government is under complete control, exercises complete control over how to deal with the pandemic or the epidemic. Now, this has numerous problems. The first is that the wide range of functions that Parliament performs is bypassed. So, for example, now the most obvious function, of course, is that Parliament meets to often vote on laws and vote on governmental action. Now, of course, if you have a majoritarian political party in power, it won't lose parliamentary votes because there's a whip system and the anti-defection law and all of that. So that maybe will not be a big change. But through the scope of parliament, opposition parties can ask questions on the floor of the house to hold the government to account. You have parliamentary questions that are put to ministers, and ministers must answer them with data. So you have the health minister. You can ask questions, about the pricing of kits, the availability of kits, and that data then must be provided, and that can be made public. You also have bipartisan committees. Parliamentary committees exist to scrutinize the work of the government on various important issues. So parliamentary questions, parliamentary debates, parliamentary committees are all very important organs of democracy that exist to ensure that that at all times the government's actions can be questioned. And so you see, for example, in the UK recently, after a long time, sorry, one sec. After a long time, the UK Parliament came back into session digitally, and on the first session, multiple questions were put to the health secretary by the leader of the opposition about the number of tests available, and from that, it became very clear that the UK government was completely unprepared for handling the pandemic. And so that kind of function then is completely bypassed if the parliament is out and only the government is taking decisions on a daily basis. So that's one thing. The second is that then that leaves only the courts, because you've taken out one wing of state, and so that only leaves the courts. But if you look at how the courts have conducted themselves over the last 3 or 4 weeks, it seems that the courts as well have abdicated their function of holding the government to account. And a good example of this is what happened with this whole issue of free testing for COVID. Now, on the first day of the hearing, the Supreme Court says that given it's a pandemic, public health crisis, you need to have free testing. But it doesn't give any reasons for that, and it doesn't explain what the reimbursement mechanism will be for the private labs that are conducting the testing. Now, 4 days later, the court completely walks back on its first order and then effectively says that only those people already within the government's insurance scheme are entitled to free testing, and then the government can decide who else can or cannot get free testing. Now, there may be multiple views on this issue, right, about whether there should be free testing or not. And one argument that's been made is that there needs to be a price barrier, because without that, private labs will not do any testing, and ultimately the number of tests will go down, and there'll be a long-term harm in tackling COVID because you're doing less testing, having made it free. That's one argument, right? Now, that argument depends upon a set of underlying facts that have to do with the price.
Gautam, you are on mute. Hello.
Yeah, sorry. At what point did it go on mute? Swati?
Yeah, you were
When-
explaining
when-
about
yeah.
COVID-19 case and testing, and there can be various points of views about it. I think
Yeah,
that's
okay, yeah.
yeah.
So you can have various debates on that. These are all questions of fact. And as developments have shown after that order, there have been numerous issues with procurement and with determining the cost, conflicts of interest, and so on in this whole during the course of getting those kits. And in fact, that was revealed yesterday in a Delhi High Court hearing, where it was found that there was literally like a 200% profit being made by intermediaries on the delivery of these testing kits. Now, of course, it's important to make a distinction here. The argument is not that the court should decide the price of the testing or substitute its wisdom for that of the government. The argument is that the court has to ask these questions. So if the claim is right that at a certain price level it will become unviable for the manufacturer of these kits, and so there will be less testing, then the underlying basis of that calculation should be made public and should be made to the court. And if the calculation is rational, the court doesn't have to step in. But the issue is that because Parliament isn't functioning, the only forum that is left where there can be a transparent and open discussion about government policies is now the court. Of course, you have investigative journalists and doing a great job, but that isn't a substitute for like an actual check or balance upon what is happening. And so the task of the court becomes very important. The task of the court is by asking the right questions to bring out what the underlying basis of these policies is. And if the basis is completely irrational or arbitrary, then to, of course, strike them down. But if not, to uphold them and then leave it up to public debate. But the public needs to know what's happening. And you see this in various other orders involving migrant workers, provision of facilities to migrant workers, and so on. There's no genuine effort by the court to actually compel the government to substantiate the claims it makes, and that's the really core problem, because the problem is one of accountability, right? So what the government is doing cannot be something opaque or in secret. It needs to be out in the public, so there can be a rational discussion about it, and there can be understanding of what the government is doing. So that's the way in which Parliament has been taken out of the equation, and the courts are themselves deferring, and that in that sense, the handling of the pandemic has basically become an executive-led, exclusively executive-led enterprise. And as I've said, that's the problem, because the whole point of the constitution of this governance structure is to ensure that there is a distribution of power. Now, one argument might be that that's all well and good for normal times, but in an emergency, you need to have centralized decision making to ensure that things get done efficiently, and so on. Now, that might be true, but there are studies now that show that even in emergencies, a collaborative model is better than a top-down model. But the interesting thing here is that the constitution itself envisages that to happen. So there are emergency provisions, and you can declare an emergency, and then effectively for that period, take over, the functioning of the government and make it, in a sense, centralized. But the government hasn't chosen to go down that path, and that's interesting because the thing is that once you formally declare an emergency, right, you are basically indicating that this is a situation that's extraordinary, but also temporary. So the emergency exists. At some point, it will end, and when it ends, then we will return to the normal legal landscape. The problem with not doing that, and the problem with invoking laws like the NDMA and the EDA, is that you give the sense that you can use these extraordinary powers without declaring the emergency. And so there's no way of knowing when it'll end. So the risk of these kinds of powers becoming just a normal part of our day-to-day life is very great, because both the NDMA and the EDA are not emergency laws. They are effectively laws for normal situations, normal times. And so once you are able to invoke these laws without going down the emergency route, and assume all these powers to yourself as the government, central government, state government, there's no reason why you would give them up, right? And so it's just easy to keep on going with that, even after the pandemic itself is over, and there are no standards by which to then judge that this is the emergency and this is not. And that actually brings me to the second big issue, which is the issue of civil rights and other rights during this pandemic. Because again, if you declare an emergency, you are entitled to suspend basic rights for a while. Not all rights. Article 20, 21, you can't suspend them, but you can suspend other rights. And there's an understanding that in order to tide over the emergency, temporarily some rights could be suspended. But again, once the emergency is over, then you have to go back to normal times. Now, what you're seeing, for example, with things like the Arogya Setu app, right, is the opposite of this. Now, imagine that it was acknowledged that this is an emergency, and the Arogya Setu app is a temporary measure designed to tide over the emergency. What would flow from that? One thing that would flow from that is that the moment the pandemic ends and it's dealt with, the app has to be uninstalled. I mean, it can't stay there beyond the duration of the pandemic. The second is that the data taken by the app must be deleted. Right? So you only can take that data to tackle this pandemic, the emergency. The moment that's done, data must obviously be removed. But if you look at the debate and the discourse around Arogya Setu, there are no indications of either of those two things. There are now reports that even after the lockdown is lifted, after the pandemic is over, you will need to take Arogya Setu app with you when you're going into metros, to travel in public transport, and so on. So this whole idea of Arogya Setu becoming a permanent feature, an embedded app that everyone with a mobile phone needs to have, that is very high. And secondly, there is no talk of removing the data or deleting it. So the data will persist even after the pandemic is over. So effectively, you introduce this app that has serious problems on the privacy front, serious problems on the data front, and you don't even give any guarantees that after this great crisis is over, the app also will be dismantled. And so that's again a concern in how what might begin as a measure to deal with the crisis ultimately just transforms normality into this permanent kind of a crisis. And that's why when people say that, look, this is a crisis, so you shouldn't be concerned about civil rights too much, civil liberties too much, we all need to pull together and ensure that we get through this. The underlying risk of that is that if we don't exercise critical scrutiny at this time, then it's quite possible that the crisis time measures just become a permanent feature of the landscape. That's one reason why it's important to carefully scrutinize what's happening on the touchstone of constitutional rights and civil rights. The second reason is something that a point that was initially made by Justice Khanna in his famous dissenting opinion in the ADM Jabalpur case. You would all be knowing about that case. This was the emergency era case involving the impunity of the state, during an emergency. And there were 4 judges who basically gave a carte blanche to the state, to Indira Gandhi's emergency, saying, the police can do whatever they want. There are no remedies. And Justice Khanna dissented and said that can't happen. And one of the things he said that, look, the real danger to personal liberty and to personal rights lies not from authoritarian governments, because it's very clear what they're doing, and the moral imperative of resisting, that's also very clear. So if there's an authoritarian government, like if it's a Nazi or a fascist government, it's very clear, the what's happening, and you know what to do about that, how to resist that. But he said that the real problem is that you have people whose intentions are benign, whose intentions are good, and they genuinely mean to address a crisis, but they do not respect the rule of law, and they overreach in addressing the crisis. So they in his words, they are men of zeal who are overzealous, right? And they overreach. And this is also why the crisis is a very important time to take note of overreach, because the temptation to overreach is the greatest in a crisis, because that's when you can say, look, we all need to pull together, and so don't raise objections about civil rights and so on. A good example of this is what happened in Karnataka, where what they did was, and I think they're still doing it, is one that they published the names and personal details of people who were quarantining because of symptoms of COVID. So they put it up online, so anyone can see who has had symptoms and who is quarantining. And the second thing that they did was they said that you must take a selfie every 1 hour and send it to ensure that you are actually maintaining the quarantine, and it will be geo-located and time-stamped and all of that. Now, one argument is that you need all of this to ensure that the quarantine is being respected, and so you have to sacrifice some civil rights to ensure that people are staying where they are. Now, the problem on the other hand is that what is a consequence of this, right, is that you end up stigmatizing the people who are, have symptoms or infected, and having COVID becomes a kind of stigma. And this also flows from this whole idea of using the language of war and soldiers, in this context, because when you're talking about coronavirus as a war, fighting a war, then automatically people who are carriers, who are infected, become the enemy, because that's where the disease is kind of like transmitted. So, but that apart, the consequence of these kinds of moves is that you end up stigmatizing people who have the virus, and what flows from that is that people who do have symptoms or are showing symptoms will not declare themselves, and will not go and get themselves tested, because they fear the kind of stigma that will result from this kind of open-ended violation of privacy, of their personal details, putting it up online and so on. And so then what you have is that in a context where the entire tackling of the pandemic depends upon identifying people who have symptoms, of isolating them, of testing and tracing, is defeated because people are not willing to self-declare. Right? And then to stop that, you need to have even more surveillance, even more intrusion, and it becomes a vicious cycle. Right? And so I think what this really shows is that it's not that personal rights or individual rights are kind of placed in opposition to the public good or public interest. It's not that you have these selfish individuals, who aren't willing to make sacrifices for the public benefit, and you need to kind of override that in the interests of public good. But these basic rights, fundamental rights, privacy, and so on, have a social function as well. And if you want to have a society that is at peace or in coexistence, and a society in which there is transparency and flow of information, and where you can actually tackle crises in an effective way, then these rights become very important for that as well. Because without them, the kind of trust breakdown that will result will make things much more difficult. And so you can see that actually rights are not just individual rights; they have a deep social function, which is why we value them and recognize them as paramount and as overriding. So in that sense, you can see that again, it might be tempting to say that, look, this is a public health crisis, there's a pandemic, and so we need to give less value to rights at a time like this. And in fact, the Chief Justice of India, in an interview yesterday, suggested as much. But that's a very catchy thing to say. It's a very easy thing to say at this time. But the moment you go a little deeper into deeper questions about the role that rights play in a society, the problems with overreach, specifically in times when a crisis gives you a chance to overreach, you find that the reality is much more complex. And again, it becomes the task of the court as a judicial body to ensure that the legal standards that it applies to adjudicate state action, like proportionality, reasonableness, non-arbitrariness, and so on, is not completely eroded during the course of the pandemic. So I'll briefly sum up the two main points, and then we can have a discussion. The first is that modern democratic structures depend on decentralizing power for two reasons. One is that you need to decentralize it to to ensure that no one body or authority has complete power, and secondly, that decision making actually is enhanced and improved by ensuring that you have power spread out across actors, domains, and so on. We have seen how the invocation of the NDMA and the EDA on the one hand, and the abdication of the courts on the other, has led to a situation where effectively the checks and the balances of the structure of democracy have been bypassed, and we now have what is effectively an executive-led response to the pandemic. And I've said why that's the problem. And the second is that the tempting response to say that individual rights should be sacrificed at a time at which you have a public health crisis. And I've said that that's short-sighted because one is that in a time like this, that's when governments tend to overreach because they believe that these things are less important, and that's why you have to maintain your scrutiny over that. And the second is that without a society that respects these basic rights, you will find it even more difficult to effectively combat or fight against a public health crisis. And so therefore, it still remains important, not only even at, but especially at times like this, to be even more vigilant about what the government is doing, what our rights are, and where the correct balance lies between the two. So on that note, I will close, and then we can start the discussion from here.
Thank you, Gautam. And that was a very good webinar in which you explained such complicated issues while going into the basics as well in such a simple manner. So I would like to start with a question. So what do you think should be the responsibility of the executive in such a situation? You said it's overreaching, but where are the limits then?
Yeah, so I think that there are a number of issues here. One are structural limits, right? So we are a federal polity, and public health is a state concern. The National Disaster Management Act allows the central government to issue binding guidelines to the states, right? So if you think about it, the basic idea, right, was that if you have a localized disaster in a particular area, like a cyclone or like a earthquake, you may need to mobilize the central government's resources and funds to deal with that. So that was the original idea animating this law and these provisions. What you have now is this pandemic that is across the whole country. So the government has declared the whole country a disaster area and is taken over management of it across the nation, right? Now, to an extent, that's fine because the central government has to obviously be the body that coordinates interstate issues, right? So, for example, goods moving across state borders or issues that affect more than one state, you need the center to coordinate. So to that extent, you need to do this. At the same time, once you have sealed off the state borders, right, and once different states are handling the pandemic, in the way that they deem fit, at that point, the government's intervention is clearly an overreach because states being close to the ground have a much better sense of how to deal with individual hotspots, containment zones, and so on. And so that's why. So when for example the center says, right, that individual states can have stricter lockdowns but not looser lockdowns, that is overreach because once you have sealed state borders, the prospect of moving between the states is not there anymore. And so then if a state has, say, dealt with the pandemic, it's flattened the curve, so to say, and wants to loosen the lockdown to kind of give the economy a jump start, then that decision is best taken at that level, not at the central level. So I think there's a clear federal issue to start with. And the second issue, of course, is the rights issue, which is that again, the executive is doing all these things like this Arogya Setu app and this Karnataka government, this the selfie and all of that. And I think again that you need to have like a proper deliberation before you do that, and that's not happening right now because Parliament isn't, Parliament is out of commission. I think that's the second kind of overreach. So you're imposing all these measures without any kind of scrutiny, oversight, or deliberation about their need and proportionality and all of that. Yeah. Okay, so there's one question: is what are the responsibilities of the members of parliament in this time? So I think that that's the thing, right? So in a normal time, you could ask them to kind of hold the government to account by asking parliamentary questions through parliamentary committees on the floor of the house and so on. But the house is not, in session, and under the terms of the NDMA and the EDA, there is no effective scrutiny of parliament over the government. So parliamentarians can't really do much, in at least in parliament, right? So what they've been doing is they've been basically, tweeting and stuff, which of course is not a substitute for like the formal mechanisms of democracy. The second is that until recently, parliamentarians had the MP lad funds that they could spend on their constituencies. So, for example, Shashi Tharoor used his MP lad funds, I think, to buy testing kits and give them to the Kerala government and so on. But now I think the MP lad funds themselves have been suspended for 2 years, so that central government gets the money to fight against COVID. So I think that right now elected parliamentarians really don't have much to do. I mean, their main forum is not in existence, and the funds they were given have been taken away. So I mean, it's hard to see what at this point meaningfully they can do, apart from raising questions in extra parliamentary forums. Yeah.
So in connection with that, we are having an increase in ODR in court. So why can't we have something like an e-parliament as well?
No, so I think no, you can have an e-parliament. The issue is not having an e-parliament. The issue is that once you invoke the NDMA and the EDA, you don't need parliament anymore, right? So basically, I mean, these are these very, very broad clauses that give the government all this power, and then basically I think the NDMA says that if you pass regulations under the act, then at some point they will be tabled before parliament. But even if parliament rejects them, it won't affect anything done in that meantime, right? So for example, if hypothetically parliament was to find at some point that the regulations are an overreach, it would make no difference, because the act says that nothing done in the meantime will be invalidated. So in that sense, I think the issue is not so much that parliament can't sit virtually, but that the structure of these acts is such that they make parliament irrelevant, legally irrelevant. There is a question. The Sarkaria Committee, while dealing with Article 352, has recommended that natural disasters, which may tend to paralyze the government of the state and put its security into jeopardy, in your opinion, do you think the government would be able to ensure a better tackling the virus move by exercising emergency provisions? Yeah, so I think that that's true. I think that turning this into a formal emergency, which I think we all accept that there is an emergency, would be a better move than this kind of insidious backdoor emergency. But I think there are a few things. One is that the limits and the contours of the emergency have to be strictly policed. So there has to be like a clear threshold, defined threshold of when you can invoke that, a clear expiration period subject to ratification, and oversight by Parliament after that's done. So in that sense, we need to clearly confine the scope within the Constitution. And at the same time, I think you also have to set out as you rightly say, the implications for the federal relationship at that time. So a public health crisis or a natural disaster, if it's a ground for declaring an emergency, doesn't mean that things that the states are best positioned to do, for example, public health, should also be overtaken by the center. So like I said, I mean, the center should have power to ensure that there is a coordinated response across, say, state borders. So to that extent, it can take over and issue guidelines. But for me, it doesn't make sense that on a day-to-day issue of how much lockdown, what's open, what isn't open, the center should be issuing it, not the states. I think it's to be the other way around. The states have a much better way of understanding that in any given locality, in any given neighborhood, what would be a better public health response to the crisis. Since a number of the rights of a number of Indians have been violated due to COVID-19, there must be a remedy. If assuming that China has violated any international treaty, can any Indian state like that in the USA sue China for compensation? And second, if even central government does not sue China, can the High Court or Supreme Court do anything in this regard? Maybe itself declaring as parents patriae or asking the center to ask as parents patriae. No, I mean the problem is that you can't. Where will you enforce this, right? So international treaties are toothless unless there is an enforcement mechanism, and there's no real enforcement mechanism here. And secondly, is that it's very, very hard to establish responsibility under international law for something like this. So unless you can show that the virus was manufactured or something by China, which I think the science clearly shows it wasn't, like it is a naturally occurring virus, it's very hard to actually fix accountability under international law on a nation state for what is effectively a public health pandemic. So I think that would act as a barrier towards international proceedings in this regard. And I wouldn't take seriously what those US court proceedings are like. They look quite ridiculous to me, quite honestly. Isn't it a harm to dignity or reputation of the people while posting their videos of punishment on social media? Yeah, I think it's very clear that's a very clear dignitarian harm. That needs to be taken seriously, and you need to like take the police to court and ensure that is stopped, and then that people are disciplined for that kind of behavior. So there are several concerns associated with PM Cares Fund and Arogya Setu app. Is PM Cares Fund valid according to law? Whether Arogya Setu app is creating surveillance state and a subsequent breach of privacy. So on PM Cares Fund, I think that many issues have been raised, specifically with respect to the lack of auditing that takes place. And I think that there are very similar issues with the National Relief Fund as well, apart from the auditing part of it. So I think I don't quite know in detail the legal structure underlying that. So I can't quite answer on the issue of whether the fund is itself legal. But I think that one serious issue definitely is the lack of auditing of that, given it's public money, and that should be, I think, taken up seriously. Arogya Setu app, yeah. So as I said before, there are serious issues with Arogya Setu, and if you go online, you'll find the amount of data it collects is much more than required. There is no sunset clause, that would stop after the pandemic is over. Now there are reports that Aadhaar will be linked with Arogya Setu app and that data will be exchanged. The prospect of health surveillance, where your medical data and medical records are monetized by private companies, especially insurance companies, is a big issue in many countries, including in India. So I think that there are serious concerns with the app, and they need to be taken seriously. And you have other countries like Singapore, which have models of contact tracing apps that don't require the kind of data and information that the Arogya Setu app does. So I think that is definitely a disproportionate response to the pandemic, and you could achieve the same kind of result, which is contact tracing, through a less intrusive mechanism, which is the whole point of the proportionality test under constitutional law. Do you think we are in the mode of writing a new discourse of human rights altogether, or is it relative to the pandemic and hence fleeting? I think it really depends on where it goes from here, because on the one hand, a crisis always gives you chances to reimagine paradigms. So for example, there's been a long-standing issue that the Domestic Violence Act. If a woman is subject to domestic violence, what happens is that she has to kind of like leave the matrimonial house and take refuge with her parents or family while the case is being pursued. And so there have been calls by feminist lawyers and groups to ensure that during the pandemic it's the other way around. It's the person who commits the violence who has to kind of leave the house, and that's something that is a radical departure from the structure of the way like the act works in practice so far. And so in that sense, and another thing, for example, is that for the longest time, there have been proposals for a domestic workers law to be put into place. And when you see that there are all these people who either force domestic help to continue working during the pandemic or dismiss them without paying them wages, you see that there's a clear time to call for that once more. So in that sense, I think you have a scope to really rethink and reimagine what we think of as human rights, specifically when it comes to marginalized, vulnerable people. But I think that again the risk is that the temptation to kind of just shut down and submerge rights by invoking public health crisis and talking about the need for unity and at this time risks basically, I think, devaluing them even more. So I think it really depends a lot on how people like you, people like all of us, ensure that these new ways of imagining rights, persist after the pandemic is over, and we think about these things even more than letting them kind of slide and go away. Payment of wages during lockdown is a burn-all issue these days. Both employer and employee are facing financial hardship. What are solutions under constitutional law? Yeah, so I mean, like, the many states have come intervene. So if you look at, for example, what the UK is doing, the UK has said that they have announced this furlough scheme, and according to the furlough scheme, if an employer opts in to the furlough scheme, then the government will pay 80% of wages during this period. So effectively, that protects both the employer and the employee. It shifts the burden onto the government, which can then be recovered through progressive taxation, higher marginal top rate of tax, wealth tax, and so on. So what you basically need to do is to, at this time, for the government to take over the obligations of paying these wages, and in the long run, rethink and come up with a more just and redistributive tax system that effectively ensures that redistribution happens by making the most wealthy pay for society's further welfare and improvement. So I think that's one way of dealing with that issue, because obviously many employers are not in a position to pay wages after a certain amount of time if their own business has been completely shut down. So you can't force them to pay money that they don't have. And that's exactly when the need for a welfare state really becomes paramount and becomes very important. And the Constitution itself doesn't say much about this, because the Constitution isn't an economic charter. I think this is more a legal policy argument than a strictly constitutional argument, apart from pointing out again that ultimately the people who bear the brunt of these measures, like a lockdown, are those most marginalized economically, because normally they're the ones who can't work from home. I mean, those who can work from home, that assumes a job in which that's feasible, the internet connection, and so on. So I think there is a constitutional issue with respect to inequality and discrimination. The remedies might lie beyond constitutional law, I think. Yeah, I think that's it. Is there any other questions?
So if any of you are having a difficulty typing, I would let you unmute the mic for now and ask a question. We'll wait for a minute for that.
Yeah, plea has been moved to the SC about nationalization of private healthcare bodies. How is this not a violation of 19(1)(g)? Yeah, so first of all, I mean, I think that this is not a justiciable issue. So the question of nationalization is not something that court can decide. It's a question of government policy. If the government was to decide that, then I don't think the 19(1)(g) issue would lie, because nationalization, as long as appropriate compensation is paid, doesn't really raise a 19(1)(g) issue per se. Employers are taking recourse to Article 14, saying that every employer is not in the same situation. Yes, exactly. So that's my point. I mean, you can't expect Facebook or Google, or like JK Cement, to take the same action as you would expect, like the neighborhood, small shop that employs, one employee. So in that sense, yeah, I mean, it can't be a one size fits all, which is why something like the furlough scheme from the UK, where at this point the government assumes the obligations of payment, and then can recover that later through a progressive tax system where you tax the wealthy more to get it back. That's the way you go about it, and that ensures that there is no the whole issue of making every employer, including small employers who don't have money, pay. That doesn't become an issue anymore.
Gautam, one more thing. You are saying that some of these issues, such as erosion of federalism, separation of powers, imposing on individual liberties, personal liberties, they can become a trend for future. But were they a trend before the lockdown as well? Before this become a
Yeah,
pandemic?
I mean, yeah. So, I mean, the lockdown has accelerated some of these trends. But, I mean, so for example, if you look at the 10th schedule and anti-defection law, so once the party issues a whip, right, then if an MP or MLA disobeys the whip, then they get disqualified. Now, that basically ensures that you can never have intra-party dissent. So it's no longer parliament as a body to check the executive. It's basically the political party that becomes the fundamental unit of governance. So the individual MP or MLA can no longer vote with their conscience or pressurize the government. They have to vote for the government. So you can see that many of these issues like federalism. I mean, the GST is something that has been severely harming federalism since it was introduced. So I think many of these issues were already there beforehand, and the pandemic has really, I think, exposed the speed and the pace at which these things are changing and kind of becoming more centralized. I mean, you also had, for example, this whole thing of money bills. So to escape scrutiny of the upper house, where the government lacked a majority, then they basically just designated, for example, the Aadhaar Act as a money bill and got it passed without Rajya Sabha, requirement assent over there. So you had all these tricks being played and all these issues, I think, with respect to federalism being undermined, the individual MPs being undermined, and effectively just concentrating power in the prime minister's office and the figure of the prime minister for a long time now, and I think almost 2 or 3 decades now that's been happening. But yeah, I mean the pandemic has kind of really sped it up and in many ways just shown it much more clearly and blatantly than it was before. If assuming that it was 2024 election time, could the government have simply postponed the election by these 2 acts, or would emergency have been necessary in that case? I think they have postponed. I think the election commission has postponed the elections in Maharashtra. I think which has led to a big controversy about Uddhav Thackeray being not a member of the assembly. So I don't think they could have postponed it through these 2 acts. I don't think that would have been done. But the election commission, I think, could have postponed it, and I think that again you can't obviously have an election in the middle of a public health pandemic, and you've seen how in the US they were having all these primaries, and now people who went to vote have been infected. So I think the election commission would have taken the call to do that, not through these 2 acts.